All right. Hi, everybody. I'm Alex Sogno from Global Asset Solution. I also lead the International Luxury Hotel Association for Europe. And today we're going to have a webinar, a legal webinar. It's going to be very interesting. Stephen will introduce the panel. Following the great success we had in Inspire 21 in December, we're going to continue our monthly webinar this year. And we thought it would be very interesting to start with all the legal challenges that we have and dispute that we may have between owners, operators, and everything this year. So I will stay in the backstage. I will let Stephen take the lead and introduce himself and the panel. Stephen, it's all yours.
Thank you very much, Alex, and thank you very much for this opportunity to participate in this webinar today. I'd like to start by introducing myself and the other panel members. So I'm Stephen Walters. I'm an M&A and private equity lawyer and a partner with the independent French international business law firm JEANTET. I'm talking to you today from our Paris office. And I'm joined first off by my partner, Ioana Knoll-Tudor. Ioana is a specialist in international arbitration and commercial and investment arbitration. She acts as both as counsel and as arbitrator. She has a special expertise in the CEE region. She heads our firm's Budapest office. And she's also a published author. She's written a book called The Fair and Equitable Treatment Standard in International Foreign Investment Laws. And she's a regular speaker at conferences and other events. So thank you for joining us, Ioana. I'd also like to introduce our other two panel members. We're delighted to be collaborating today on this webinar with our friends from KATTEN. So KATTEN is a US headquartered international law firm with over 750 lawyers across the US, in London and China. Our two panel members today are both members of KATTEN's London office. KATTEN is one of the leading US headquartered real estate and hospitality sector law firms. Kumar Tewari is the third of our panel members today. Kumar heads the private credit group at KATTEN's London office. He spent almost 2 decades practicing as a debt finance lawyer, including nearly 10 years working in the banking industry as a head of legal department, and also in a commercial role as director of a major listed bank in London. Kumar represents global banks, alternative and direct lenders, agents, investors, and sponsors across all levels of the debt capital stack, and in particular on senior mezzanine loan structures. He regularly advises clients in the real estate and hospitality sector. Our fourth panel member today is Tim Dodd. Tim is a lawyer in KATTEN's London hospitality practice. He represents a broad range of hotel and hospitality clients, acting for major international hotel operator companies, hotel owners, property companies, multinationals, developers, and so on. Prior to joining KATTEN a couple of years ago, Tim spent several years as in-house corporate counsel with international hotel operator brands, negotiating management agreements, franchise agreements, and other transactions for the company's operations around the world. Outside of the UK, Tim has experience in Southeast Europe, Central Asia, and Africa. So between the four of us, we hope to bring different perspectives to bear on today's topic, which, as Alex indicated, is disputes in the luxury hotel sector, how to avoid them, and if you are unsuccessful in avoiding them, how to manage them. I'd like to start by addressing a question to Tim. So Tim, your particular area of expertise is management agreements, operating agreements, very much the nitty-gritty of the sector, and of contractual relationships between different stakeholders. In your experience, what are the commonly encountered provisions in management agreements for resolving disputes between an owner and a hotel manager?
Thank you, Stephen. Wonderful to be here. Yes, interesting question. I think, first of all, we need to establish that hotel management agreements tend to be long-running relationships. These are 20, 30-year relationships between the hotel owner and its manager. And like all good relationships that are profitable and that are stable, I think this whole doctrine of regular communication and regular correspondence between the main sort of stakeholders is absolute key and paramount. And the hotel management agreement often prescribes for this. It recognises the importance, and it will prescribe for this in its terms. For instance, it will put a monthly obligation for both parties to discuss the financial results of a certain month for financial projections going forward and for any operational concerns. Quarterly, it will put in an obligation for the parties to meet to look at the general state of the hotel itself, the building, the state of the FF&E, and any operational concerns that may arise then. And of course, the owner and the operator will be meeting on an annual basis anyway, in order to discuss and review, share comments on the draft annual plan that the operator, the manager, will put together. So there are a number of areas that the hotel management agreement actually prescribes, and it's important for the parties to congregate and discuss their on. Having said that, the management agreement obviously also outlines resolution procedure, which often, first of all, encourages parties to try to resolve their disputes on a personal basis in the first instance. So senior representatives from the owner and from the operator will come together and try to sort of like unlock those areas of concern. The management agreement is often very keen as well on introducing an expert determination, which is a very sort of suitable and time cost-efficient method of enabling commercial areas of concern to be resolved by an expert, which is either an individual or a company with a whole load of years of hospitality experience under their belt, and who've heard and resolved similar familiar disputes time and time again. So an expert may be brought in, for instance, to determine the constitution of a competitive set when looking at the RevPAR arm of a performance test. Or it may be addressed where there are areas of concern or dispute over line items of an annual plan. The expert may be brought in for that. And I think such has been the sort of like the wealth and the value of the expert, that it's often been brought in now to widen the scope of the issues upon which it opines. So that it might be brought in to advise on or provide clarity on a brand's operating standards, or upon development milestones of a project, which is fine, provided that the owner and the operator recognise this. But the hotel management agreement is very particular that the expert can advise on these commercial areas, but there are other areas of legal concern where, of course, the expert can't advise. And so it'll be down to the conversation between the principals and then going forward to litigation.
May I ask you a question just about the expert? Have you ever seen expert appointments go wrong? And what happens if the parties are unhappy with the outcome of an expert's determination?
Well, the expert determination, yeah, things do go wrong, but the contract normally is very clear as to and very transparent as to the appointment of the expert. So the parties will agree upon an expert in order to listen to the grievance. And if they can't agree on it, then another sort of like body will actually appoint somebody who's very well experienced. If the expert determination doesn't go according to plan, for instance, if there are issues that still remain outstanding on line items of an annual plan, then the next year's annual plan will start, but those areas of dispute will actually be parked, and those line items will be governed in accordance with the previous years. Where the expert determination isn't satisfactory, then unfortunately these things will not normally then go to arbitration, which I know Ioana will come on to a bit later on during this webinar, which can be a bit more of a timely and costly process. So where there are commercial areas of concern, it certainly makes sense for the parties to try to resolve it through expert determination if they can't resolve it themselves through their own senior associates.
Understood. But would it typically not be the case that the expert's determination, even if you don't like it, there's not much you can do about it once it's been delivered, because the parties agree that it's final?
Absolutely, and there will be provisions to that extent in the management agreement itself to say that the expert, further to the expert hearing both sides' concerns and their gripes, it will provide this determination that will bind both parties.
Understood. In your experience, Tim, I'm interested to know, what have you encountered as the most common battlegrounds between owners and managers, and what sort of tips do you have for the audience about how to win those battles? Whether they're sitting on one side of the table or the other.
Sure.
Got quite a broad audience here today. Different types of stakeholders. So.
Absolutely. Well, I think there are frequent common battlegrounds within all management agreements, and I think it's probably born of the fact, the nature of the relationship between the owner and the operator. And if you look at these individual entities in the first instance, first of all, you've got the owner that owns or has title to the land. It will own the building. It will own the business. It will fund the actual construction of the hotel, or it will fund the property improvement works or refurbishment to its existing assets. It will provide the initial working capital. It will provide gaps in working capital throughout the term. It will fund for major alterations. It will fund for emergency expenditures. So therefore, it probably feels as though it's owed a bit of a right in order to advise or have some sort of like approval rights over the expenditures of the business. It probably feel as though it's owed some right of priority in terms of its monthly return, and it will certainly want to feel as though it's got the right to actually terminate the operator at will to the extent that the performance isn't working out quite the way that it wanted to. The hotel operator, on the other hand, I'm saying the word just. It's a service operator that's providing its day-to-day operational services under its flag for a nominal fee. And so these two parties are coming from entirely different areas, and it's often that clash that creates the most frequent battlegrounds within a management agreement. So you've got the owner wanting to have a more hands-on approach, and you want the operator really wanting to say, look, we're experienced in this, we do this globally, kindly leave us to it and we'll provide you the most efficient and profitable operation. I think probably the tips it goes pre-drafting. It's when the hotel operator's development team might go and have their initial discussions with the owner counterparty before signing the term sheet. And it might want to incentivize an owner with whom they haven't had much of a relationship before. And that incentivization might be through the provision of key money. It might be willing to give a performance test. It might be willing to offer, let's say, an unfunded FF&E reserve. It might be willing to give some sort of like owner priority or subordinate the incentive fee for a certain period of the term. Just things to get the owner comfortable that following on from the ramp-up period, he will be left with a very efficient, fluid-running business that the hotel operator can fluidly run under its flag. Of course, there will be areas where the owner and the operator will meet, as we previously discussed from your earlier question. But the owner should be satisfied then and be a bit more comfortable that the operator is obviously working a very well-oiled machine to maximum efficiencies. And I think that the owner must appreciate that it's engaged the operator because of its reputation, because of the performance results that it's got, that it's obtained in other operations throughout the world, and it will leave it to its business.
Understood. Are you seeing this question? We've not programmed, Tim, so I hope you don't mind me asking it, but it's kind of interesting to know what your thoughts are. Are you seeing any trends in terms of the convergence of terms in management agreements? I know there are a number of industry standard models out there. Where does the balance of bargaining power typically lie, and are you seeing any sort of movement in that direction? in favour of operators or of owners? What's your sense of that?
I think it really depends upon the operator. I think it depends upon the relationships. If you're a major global brand and you've already got a number of different operations with the same owner globally, then that owner is likely to sort of like be totally comfortable, will leave you alone and let you sort of like provide the profitable sort of efficient running of the business. I think it's harder, obviously, for smaller operators, perhaps that we're not addressing on this webinar, but those operating in the more budget end or the upscale end of classifications. Perhaps if they're a new entrant to the market, then they're going to be very lucky in order to get sort of like favourable terms for themselves on their first few operations, which is perhaps understandable. And in those instances, the owner will be taking a bit of a risk, and it will want these approval rights over the expenditures, over contracts being entered into. It will want a bit more of a priority in order to make sure that it's getting its money back. And it will want the ability to actually terminate operations if things aren't quite going as planned, because there might not be the precedence with this new entrant. But for established operators, I think, you know, with good running relationships with same owners, I think these are more fluidly, less negotiated management agreements and things that can get fully up and running as soon as the property improvement works are ready and the owner's box, if you like, has been designed to the brand standards and the design standards of the operator.
Understood. I've got one last quick question for you before we turn to Ioana. I know that a number of your clients operate franchise models, Tim. Could you tell us a little bit about the specificities of disputes under franchise agreements and you know, how those disputes are typically resolved?
Sure. You know, it's a different dynamic under the franchise, and perhaps it's not so prevalent in the luxury hotel space. But in any event, here, the actual brand owner, if you like, is not on the floor operating the hotel. And I think it's that absenteeism that causes it concern. The franchisor is entrusting its most valuable asset, being its brand, its IP, with a third party, which could be a franchisee or a third party manager, in making sure that it's not going to do any brand pollution or damage to the brand's reputation. So I think the main things that the franchisor will want here are often embedded in the franchise agreement. And that is sort of like a right to undertake inspections at any time, a right to insist upon rectification in relation to any issues that the inspections throw up, a right to approve any property plans, refurbishment plans, ideas for works, just to make sure that everything is in line with the brand standards of the franchisor. And it will also want the right to train up all the executive staff, just to make sure that it's sort of like hitting the appropriate service standards of the brand. I mean, and as you mentioned there, Stephen, I mean, the franchise world, yes, I mean, we do get involved in this quite heavily at KATTEN, perhaps not in the luxury sector, but we have had experiences where we have two parties, a franchisor and a prospective franchisee. The franchisee wants to go to franchise immediately. The brand's not so sure. And so the halfway house is to do what's called as a manchise agreement. So to start off the operation under a management agreement, whereby the brand is on the floor, it's basically ramping up the operation, it's making sure it's fluid and efficient in accordance with system standards. And then once it feels as though that ramp-up period's gone well and it's trained up staff, then it will flip over to the franchisee. And assuming that the franchisee has adopted appropriate corporate structures to support accounting, to support HR, the training, the sales and marketing, then the brand might be more comfortable in having the operation then flip to a franchise operation.
That's interesting. I had not encountered the neologism of manchise before, so thanks for adding that to my lexicon. Those are great insights. Thank you very much, Tim. I'd like to turn now, if I may, to Ioana. Now, Ioana, of course, is the person people call when they've decided to go to war because all else has failed and they need to reach for the heavy artillery. So, Ioana, I'd like to ask you a little bit about obviously the management of the disputes themselves. And perhaps we could start with the drafting of dispute resolution clauses, because of course, as we know, any well-drafted contract would typically have a clause in it which specifies, what the parties are to do if a dispute arises. What are your what would you typically advise your clients as to the way to go? Because I know there are choices to be made here.
Hello, Stephen. Hello, everyone. It's really a pleasure to be here. And thank you, Tim. It was extremely interesting to listen to you. And I think this is what's great about these webinars, is that you, of course, prepare and you're ready to give information to the others, but you're also learning a lot from the other speakers. So it is, at least personally, extremely interesting to listen to you. Yes, it's true. When we intervene in a file, usually there is a problem, which is the reason why we are called. And it's true that Tim detailed all the options that exist in a management agreement, or that you can include in a management agreement in order to prevent disputes, but sometimes that is just not possible. So probably the best or the first advice I would have to give is that you have to make sure that there is a dispute resolution clause in your contract. I know this may seem rather obvious, but trust me, it's not. This is really one of these clauses that you leave for the last moment of discussion. It also means that not only don't you have the time to properly negotiate it, but it also means that very often we encounter pathological clauses which, at least in terms of arbitration, you cannot put into operation. So maybe the first advice, make sure there is a dispute resolution clause. There is a reason why it is called the midnight clause, really the clause that you are thinking about at the very last moment. So first advice, make sure there is one. Second advice, to the extent possible, and depending, of course, on which side of the table you are, it is often very well if you can have a template clause, one for, let's say, litigation, one for arbitration, that you've thought about in piece, in detail, and that even if you try to adapt it to, of course, the contract that you're signing, at least you start from a healthy base. And this is something that I will never stress enough, especially in arbitration clauses, in which without an arbitration clause, arbitration is not possible. It's really important that the arbitration clause is operable. So it's important to have a template clause that you think about before that midnight moment when you need it. So that's probably the second advice. And the third advice, and it goes very much hand in hand with what Tim has been talking about, all the various methods of preventing the dispute, is what we call in our jargon, and I hope to add to your lexicon, Stephen, if this word is not there already, the escalation clauses. So basically, in dispute resolution, of course, you go to war, and we are always ready for that. But of course, it's always in the best interest of the client to maybe try to find a settlement, a solution which is out of court or out of arbitration. And for that, the way in which you do it is that you leave or you set already in the clause a moment for discussion between the parties. That can be done in various ways. It can be simple negotiations, it can be a conciliation, it can be a mediation, and it only once this moment is finalized with a solution, or unfortunately unsuccessful, that you decide to go to arbitration. To be paid attention to the fact that in many jurisdictions in Europe, if you have planned for a pre-litigation or a pre-arbitration phase, if you decide to go directly to arbitration or directly to litigation, the arbitral tribunal or the court may consider itself not competent if you haven't gone through that process of pre-arbitration or pre-litigation. So just pay attention. If it's there, is not just an option. In many jurisdictions, that is the case for France, it is considered to be a pre-phase to litigation or arbitration.
Ioana, I have a question. Going back to the dawn of time when I started practicing, I picked up along the way some knowledge, and I'm hoping you'll be able to tell me whether this is correct or not, that sometimes you have a conciliation and arbitration clauses. And what I thought I had understood many years ago was that conciliation was not a good thing to build into an arbitration clause. In other words, it was better just to have you go straight to arbitration, and you don't sort of prolong the agony or introduce a sort of structured, formal first stage of conciliation. Am I right about that? What would you generally advise if you've got an arbitration clause? Should it be conciliation and arbitration, or just straight to arbitration?
Well, what we see in our, I would say in the majority of our cases, is that, first of all, by having a conciliation that can also be a mediation or however you want to call it, but just a phase in which the parties sit at the table and try to find a solution. Even if that, first of all, you can find a solution, that's totally possible, but it also allows the parties to prepare their case for arbitration. I mean, oftentimes in a big company, you have different services. The legal department is just that department that you're going to when the problem arises, but very often they are not informed and they haven't followed all the operational phases of the project. So when the dispute arises, if you go straight to arbitration, which is of course totally possible, the legal department is there trying to build the case. It really at the last moment before the case has to be put in front of the court or of the arbitral tribunal. Whereas if you already go through the conciliation process, it also forces the parties to build their case, to go back to the operationals, to understand the case, to have a bit more time in a way to prepare for what's coming next. And another point which, I mean, those who listen to us are potential clients, but you have to understand that every single client thinks their case is absolutely the best, and there is absolutely no way they can lose. However, by doing this conciliation phase in which you have time to reflect, to hear the opponent's arguments, to hear what actually they have against you if you're defendant, but also to assess what are your strengths and weaknesses in a case, very oftentimes brings reality into discussion. It's not a bad thing. I'm
very interested to hear you say that, and you're preaching to the converted. There is a sort of little case study I'd like to share with the group in a few minutes on exactly that theme. But before I get into that, I have another question for you. As we all know, I think there is an essential choice to be made between litigation before the national courts, and of course there may be a choice as to which national courts you go to in an international contract on the one hand, and then international arbitration on the other. And of course there are also choices as to the forum for international arbitration. What do you usually tell clients they should do?
Well, I, of course, use the totally lawyerish answer, it depends, meaning that there is no solution. There is no solution that fits all cases. I mean, clearly, there are advantages for arbitration. There are advantages for litigation. Probably, just to give a couple of advantages and disadvantages, or at least points to consider when you make your choice. I would say that in a sector which is rather limited, as the hospitality sector is, confidentiality is extremely important. It's extremely important because the number of actors interacting in this market is rather limited, or at least people know each other. They may be working together now. They may be working together in 5 years from now. They have interactions, which mean that oftentimes, even if there is a dispute at a certain point in time, they will continue their business relationship, in the future. And confidentiality, which is applied to arbitration, I mean, you just to be very clear on things, if you have an arbitration clause and you're in front of the arbitral tribunal, all the discussions in front of the tribunal, including the award, are absolutely confidential, and they are only between the parties which are a party to that specific arbitration, which means that even if you have a decision which is in your favor or not in your favor, or if you have a point of law which is decided upon by the tribunal, the only parties who have that information are those around the table. And that, I think, is extremely important to keep in mind. At the same time, in litigation, you don't have this confidentiality, but you may even use this threat of litigation in a way to be able to maybe even more find a solution on a settlement rather than having this threat of we go to court, and in that case our case will be up in the public eye. So this confidentiality versus publicity of the litigation is something that you really have to deal with when you make your decision. The other point is the cost of arbitration, which we all know is rather high. So of course, if the dispute in the amount in dispute is not very important, it doesn't really make sense to go for arbitration. You have situations in which you cannot really rely on national courts, or at least it's a bit unknown In that case, of course, you'd rather go for arbitration because at least you can choose your arbitrator, somebody who has the expertise. I mean, when you listen to Tim and all the very specific points that that you have to take into account in these agreements, if you choose your arbitrator, you choose somebody who's familiar with the industry, who is familiar not only with the contractual parts but also with the equilibriums that one has to find in a relationship. So that's something to keep in mind. Whereas a judge, well, you never know who you get as a judge, you never know what the experience of the judge is, and the judge will deal in the same day, from a typical debt in a normal contract to an M&A deal, etc. Now you'll have somebody who will listen to your case, who will be knowledgeable, and that's, I think, rather an important thing. Language. Oftentimes, of course, when you have to deal with in international cases, of course, except from the courts in which you speak the language, don't forget that you will want, even if you have an absolutely brilliant lawyer, you will want, first of all, to be able to follow the procedure. And also, oftentimes, all the contractual documents will be in one language. And if you go in front of an Estonian court, well, if everything is in English and you have to translate everything, we don't realize, but the costs are really very, 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 very high. Whereas in an arbitration procedure, you can agree on the language of the proceedings, but you can also agree that certain documents in a certain language, which is known to everybody around the table, may very well not be translated. So you have a flexibility in terms of language, which is very important to point. I could go on and on. This is just to say, yes?
Well, one distinction, I don't think you've touched on this, that again, I've always, I think, been aware of, is that essentially, with very few exceptions, if you submit to arbitration and you get to the point where the arbitral panel makes an award, that's the end of the story. There are no rights of appeal against an arbitral award, or at least the rights of appeal are usually very limited. Whereas, of course, if you go to the national courts, there's typically, the right of at least one level of appeal beyond the initial judgment, and often two. It's always seemed to me that that's a bit of a double-edged sword, and I'm not quite sure how you advise clients as to which is the better sort of solution from that point of view. What's your thought on that?
Well, the first thing about that is to say that you cannot appeal. Absolutely agree with you. There is no appeal, but you can annul the decision. You can try to annul the decision, but only on procedural issues, like, for example, due process not being respected or the arbitral tribunal not being well constituted. So the annulment procedure does not allow to look back into the merits. It's true, there is no recourse to an arbitral tribunal decision. At the same time, you can also consider that an arbitral tribunal will really dig very, very deep down into the arguments of the parties. You will have very often experts appointed by the parties, experts appointed by the tribunal if needed. You will really have a lot of weight put on the witnesses. So what I mean is that before you reach an award, all the steps to reach the award are probably more thorough than in front of a court in which the judge has less time to consider your case. And then, of course, you'd like to have an appeal just to make sure that your case has been heard properly. So I think that what I put in front of the recourse of an appeal in front of the court, on the other side in arbitration, probably before the award, there are more thorough steps being taken. Let me just add one point, and I promise I stop after that. One point which has to be kept in mind. In terms of arbitration, if the parties reach an agreement, the arbitration can stop at any time. And whatever fees have been put forward by the parties will be given back to the parties proportionally given the stage of the dispute. And that's very important, because even if you lodge an arbitration in front of the ICC, for example, which is the most used institution, and you have to pay in advance certain amounts, the moment you stop the arbitration, everything is given back to the parties, except, of course, for the work already done. And you can ask the arbitral tribunal to render an award on the settlement reached by the parties, which means that you can enforce that settlement. You have guarantees of enforcing which are even higher than just a settlement between the parties. And I will only say that. No, nothing. Unless you have questions, of course.
We'll turn off the tap for just momentarily. But thank you very much, Ioana. That's very very interesting.
Thank you.
Before I turn to Kumar, I'd just like to share with the group, picking up on your remarks about conciliation, to tell you the story briefly of an informal conciliation process that I was involved in a few years ago, because I think it's quite an interesting example of where conciliation can actually work very, very effectively. So just to paint the picture for you briefly, it was a situation in which it involved a luxury hotel. A dispute was brewing between the two owners of the property. They were 50-50 owners. There was a shareholders agreement, but it wasn't very well drafted. It had, well, we didn't draft it, I hasten to add. It had ambiguities in the agreement, and those ambiguities would have added fuel to the fire if ever it had gone before a court or an arbitral panel. There was a deadlock procedure, as you would expect in a 50-50 joint venture agreement. But the deadlock procedure clause was drafted on terms such that neither party was keen to pull the trigger on the deadlock procedure, because there was kind of no going back once you went down that route. The dispute had been brewing for a number of years, and I think essentially there were various strands to it, but essentially the problem was that there was it was an asymmetrical situation between the two shareholders as regards information about the asset and its operations and their respective sort of proximity to the asset. Both parties had very good asset managers involved, but only one of the, I thought you'd like that, Alex. Only one of the parties had been involved since the beginning during the construction phase, and the other had invested in the asset, I think, when the construction phase was complete. The asset was under management with one of the major international operators, but they weren't part of the dispute. There was no problem with the operator. It was really just between the two owners. And the problem that we had and that the parties had was that the dispute was worsening against the background of plans to organise a sale of the asset. And of course, that process would have been impossible to execute whilst the dispute remained unresolved. So we really had to do something about this. What we used was pretty simple. We didn't invent the wheel, and I'm sure when you hear what we did, Ioana, you'll think that it was really very, very basic. What we did was each side prepared its arguments in advance. We didn't prepare fully drafted pleadings as you would do, Ioana, if you knew we're going to present to a court or an arbitrator. But we did prepare the main arguments that we would expect to use before the court or the arbitrator if the conciliation failed. We didn't exchange those arguments in writing or anything of that sort. What we did was that we got the parties together at the offices of one of the law firms involved, and the key, and we got them together for a day. And the key stage in the conciliation process was during the course of the morning, when basically each side's lawyer laid out verbally its and its client's version of the facts in dispute and the contractual and legal arguments that it would make if the thing went to court, if the dispute went to court. The other side just sat there and listened. It wasn't very easy, I think, for the other side to listen, but it goes back to your point, Ioana, about each party being convinced that God is on their side and that consequently the court will inevitably, or the arbitrator will inevitably be on their side. And this process was, I think, a bit of an awakening for each of the parties. But as I said, not very comfortable, because they just sat there and listened while the other party's lawyer sort of explained all the bad stuff that they were going to argue before the court. We broke at the end of the morning so that the parties could sort of each party could go into a huddle with its counsel. At that point, I think the lawyers involved, the process could have ended then, frankly, because we had no way of knowing where it was going to go. But we had sketched out together the broad outlines of a settlement agreement and a process for organising the subsequent sale process and so on. And happily, when the parties got back into the room again at the beginning of the afternoon, they were willing to enter the second phase of the day's proceedings, and by the end of the day, we had thrashed out a settlement, and terms had been agreed, so that we could move forward. And within 18 months of that day, the owners had achieved a successful sale of the asset. This was obviously a great experience, a great outcome. I think the keys to success, first of all, special pleading here, obviously, but I think the parties had good counsel on both sides. We had a very good rapport with the other side's counsel, and clearly that helped. The parties had lawyers who were willing to put their interests ahead of the lawyers' interests, because, of course, it would have been a very attractive litigation matter, I suppose, for the lawyers involved if it had gone through a dispute. But it would have been hugely value destructive for the parties if the conciliation had failed, or if we had not attempted it at all. I think also we had very smart people around the table at the level of the principals. They were clearly willing to listen, and they were willing, and they were smart enough to keep their eye on the prize. I think feelings were running quite high running into the conciliation meeting. Both of the parties were feeling aggrieved, felt that they had been hard done by, but they managed to overcome that, and I think it was greatly to their credit that they did keep their eye on the prize, and they made sure that at the end of the day, they didn't leave the meeting in Paris without an agreement. So I'm sure it won't always work. There has to be a sufficient sort of convergence of interest and alignment really underpinning the situation. But when it does work, it's certainly worth considering, because it can be a great way to go. I don't know whether anyone wants to add to that, but I'd like now, if that's okay, to turn to Kumar. So Kumar, obviously a very experienced finance lawyer with a lot of experience in the hospitality sector. I wonder if you could share with the group and the audience, looking through the lens of creditors generally, what you've seen in terms of changes in the debt finance markets in the last year or two, I guess, since the onset of the COVID pandemic, in terms of key learning curves and recent developments in the debt markets, in particular for hotel owners and operators.
Certainly been an interesting time over the last 24 months or so, that's for sure. But I think the key, reassuringly, I think the key learning curves have, for the best part, been fairly obvious ones. As you all know, global debt, it sort of really does underpin a number of these structures, and plays a critical role in bringing, I suppose, to fruition successful schemes. And it's just a component of the way the sector and the market works in hospitality. As Tim and Ioana have sort of already alluded to, the global influence of brands and the power of the brands, certainly as far as the operators are concerned, is at an all-time high in the sector. And you heard a bit from Tim and from Ioana about just that sort of tension between owners and operators, and really sort of from Tim's lens, that sort of pre-contract embedded within the contract, those ongoing discussions and how those play out. And of course, Ioana explained a bit about life when you look through the lens of dispute. And really what that means is that from a creditor's perspective, they also need to pay attention to the entire matrix of discussions and contracts, because ultimately, with debt being the spine that runs through the successful delivery of these schemes, it often brings creditors, I think, neatly to a point in the proceedings, I guess, where you have this genuinely afflicted third party that's provided debt that needs to now engage with the stabilization of the asset, particularly in a distress scenario. So to a large extent, regardless of a creditor's class or the creditor's investment strategy, one of the key learning sort of points, I guess, has been there's been a greater shift towards a much deeper level of credit modelling when looking at both your existing portfolio of loan assets, but also, when looking acutely at strategic or opportunistic investments. That level of credit modelling goes a bit further. It talks to operational due diligence, a higher level of operational due diligence, particularly in light of the way the markets have been trading over the last 24 months or so. For I suppose for us as lawyers, that then translates into a much more involved, considered approach to legal due diligence in particular as well. And when we're looking at M&A activity, when I, for example, am advising on credit agreements and security nets and sort of just structures really that work with debt, the questions, the lens through which creditors are looking at their risk is one that really contemplates now, I think, a much wider matrix of discussions. Not that I'm saying that didn't happen before, but I think in light of the market turmoil, I think creditors, particularly those that have been left exposed in the down market, are paying more attention. And that's one of the key learnings, I think, is understanding, it's an obvious point, as I said earlier, but understanding the legal documentation and the key protections that documentation affords you, I think, is critical, particularly when looking at ways in which to protect your asset or your collateral strategies and to ensure that that collateral strategy around your investment is enshrined for not just one class of creditor, but potentially for other classes of creditor, especially in multi-debt structures. Tim mentioned it earlier. I won't cover it in any more detail than he did, but I think from a creditor's point of view, it's pretty clear that understanding the way the management agreements work, understanding the way in which the non-disturbance agreements work are essentially key. And I think a well-advised creditor is one that will take a deep dive into the due diligence on those agreements and really understand, where the credit support sits, where the guarantees sit, how they work, what other potential competing claims there may be on that creditor's debt that need to be regulated by way of an intercreditor or some other form of priority agreement. And also, I think it allows the creditor or any class of creditor to really step into the shoes of both, the operator and also the owner. And I say that loosely, I don't mean to step in a legal sense, but just really to look at life through the lens of those conflicting interests, because that's really, I think, where the credit agreement and the creditors will come out best in any post, default scenario. I've mentioned it, briefly, but of course on the larger schemes, and it's really important, I think, to understand that on the larger schemes where you have one or more classes of creditor, typically there will be, in light of that debt strategy, there is likely to be a robust intercreditor arrangement, and that's really a key takeaway here, certainly from my perspective. The intercreditor over the years, as an agreement, as a construct, has not just for hospitality, but more particularly, I think, for leverage finance and for real estate finance, has really become quite a complex beast. It's got, it has bells and whistles, and you name it. It is the sort of like the fighting ground, if you like, the battleground for how claims are to be disputed and decided and resolved in an enforcement scenario. It really is a critical document. Understanding your intercreditor agreement is an important first step, and because it sort of then begins to determine the fact pattern between how different classes of creditor are able to apply financial stress on an asset, on a borrower in particular, and what impact that may have on an operator. And within the sector, it's really important, I think, to just understand that different investors, creditors, have a different psychology depending on how they come at the overall credit piece. So, for example, you have private debt funds, which make quite a large section of the global debt that's available. They, of course, have potentially have a different approach to traditional banks, pension funds, insurance companies, and then, of course, you have CMBS on top of that. Each type of creditor will essentially have a different investment strategy, a different level of flexibility in terms of how it decides to deal with an asset. And I suppose from an owner's point of view, ultimately is likely to have a different view on enforcement and how quickly a creditor may be inclined to sort of press that button, enforce over the asset, and bring the house of cards down. Thankfully, in the UK, for the best part, there have been a lot of government schemes and support schemes available, and corporate insolvency, certainly in the UK, insolvencies have been at an all-time low, and creditors, I think, generally have shown such a high level of maturity and support and a willingness to support the sector that we haven't really had yet many sort of big headlines being sort of made in terms of the sector.
Kumar, forgive me if I'm going to go off piste with this next question. I hope you don't mind, but I'm interested in your thoughts. You mentioned government schemes, state guarantees, and things of that sort. Could you just give us in the UK, what's your sort of forecast for the impact of the winding down and withdrawal of that support in the UK economy generally, and specifically in the hotel sector? Do you have any thoughts on that?
I think Stephen, it's probably a global question insofar as hotels, I think, around the world, hospitality around the world has been deeply impacted by events over the last 2 years. I think as far as making predictions for the future, there's a part of me that says, it's difficult to really kind of crystal ball gaze over it, but there's a part where you think quite rationally, well, the businesses, a number of businesses have struggled. The support available to those businesses is winding down, and for a number of owners, there will be some very, I think, realistic discussions coming up. If those discussions don't materialize in a way that allows those owners to continue to operate, then you really are looking, I think, down the barrel of a potential wave of distressed assets coming onto the market. Loan assets that need to be either refinanced quite aggressively below par, or frankly, in some instances, I think some investors may well have a better outlook in terms of an enforcement strategy. And I think that's just part and parcel of the ups and downs that the sector has faced. We won't, of course, get to hear of all of those potential, scenarios, but I think as time goes by, you may start to hear about some, significant schemes that have, not, delivered in the way that they should have. With all of that said, I think creditors globally, creditors that invest in and have a strategy for hospitality, I think have a really mature outlook. I think they understand that the issues that owners have faced are, they're sort of semi-political in a way. They're not so much financial or fiscal in the sense that pre-COVID, for example, for a large part, I guess, a large number of those businesses were working extremely successfully. A large number of developments that were coming online were doing so because there was a really strong credit appetite on behalf of lenders to invest in those assets, for hotel owners to buy and purchase and develop those assets. So this is really, I think, a scenario where...
Don't you think, though, that, Kumar, that creditors, lenders today, because we're 2 years into the pandemic, that they're also going to... I agree entirely with what you were saying there about the fact this is sort of... it's almost an external event. It is an external event affecting the sector. But the creditors today are surely going to be taking account of the manner in which individual debtors, individual operators and owners have reacted to events, are managing their way through this crisis, if they have any sense, with the help of people like Alex, to give them good advice about, how to manage this, these extreme market conditions which have been brought about by the pandemic.
I completely agree, and it goes back actually to my earlier point. Credit modeling, credit underwriting, understanding operationally at a deep kind of due diligence level, that exercise that creditors do now, and the legal exercise that they do, is really quite elevated. I think creditors are looking very closely. They're doing a double take really on the investments that they have, and they're doing a double take on potential future strategic investments too. And I think that slight shift in approach, really understanding what they're sitting on, I think will be what determines the outcome for a large number of those investments.
Understood. I'm conscious that we're running out of time and we're coming to the end of our session. I wanted to just finish with one further question for you, if I may, Kumar. It's about cash flow forecasting and testing, and the kind of options that are available to owners in a distressed scenario. Could you say a few words about that before we wind up?
Yeah, sure. Well, obviously, occupancy rates have been hit really badly, right? And there's been a steady but very slow return to the sector. So levels of, I think universally regarded globally as being well below pre-COVID levels. And all of that has a natural impact to the way a number of these credit agreements assess, the ability of the operator to service that debt. So, you've got cash flow testing that typically happens in a credit agreement. You have other covenants that look to loan to value. You have covenants that measure your ability to service your debt, the interest cover ratios, the ICR cover ratios. And intrinsic to all of that, particularly to the way businesses have struggled to generate an income, is broadly your ICR covenant. So it's been difficult to test covenants. It's been difficult for borrowers, owners to, aside from thinking out of the box, or having recourse to deeper pocket sponsors that have the ability to sustain them have had the abilities to sustain them over the last 24 months. It's been a really difficult time, and so there have been, of course, scenarios where I think borrowers in particular have, certainly more powerful borrowers have been able to look more widely around what's on the table, what other options they have open to them. And there are a few, and some of these, apologies, they are fairly obvious, but and just to add, in the sort of scenarios that, say, Tim and I see in our sort of day-to-day role, we often see multi-creditor scenarios where you have different stacks of, different sort of levels of debt in the debt stack. It isn't always possible, to achieve an alignment, but it all comes down to, of course, the quality of the intercreditor, the way it's been drafted, and so on and so forth. But for the best part, at a very basic level, leaving aside the complexities of the way the debt's structured, borrowers have had, I think, some avenues to look at their current debt, to look at the way their covenants are performing. And one of the first but most obvious things is, for any borrower that's in default or is beginning to trade in default, is to be realistic, to talk to your creditors, to strike a new deal with your lenders, to figure out whether there is the ability within the documentation, within the credit appetite, to relax those covenants. Can you reduce the ICR? What will it take for the lender to increase its loan to value? Do you need a different type of lender involved in the debt capital stack? Of course, banks lend very conservatively. Debt funds and non-bank direct lenders will go higher up the leverage stack. Essentially that, I suppose, for a borrower's perspective, comes down to pricing. But essentially, can you talk to your lenders? Can you restructure your facility? Can you relax your covenants? Is it possible to refinance the debt to a new creditor? But bearing in mind, of course, that a new creditor may not look as favourably to an asset that has an existing high level of LTV, or has where the owner's not been able to service the debt, so the ICR covenant's been breached. Banks, of course, have very stringent requirements.
So, from the point of view of the debtor, it sounds as if the bottom line, Kumar, is keep calm and carry on, be realistic, and engage in dialogue.
There are a couple of other things, I think, as well, Stephen. I mean, thinking out the box, owners potentially have the ability to think strategically. So you could, there are instances, of course, where owners may do a sell and lease back. That's one option. Another option, of course, is a debt for equity. Consider giving your creditors further skin in the game, potentially some upside. But to Tim's point, final point I'll make is, of course, if a owner doesn't already have it, teaming up with a strong operator may provide that sort of level of credit appetite that a new lender would look at, and it could potentially bring an asset could return an asset back to life, sort of, more favourably. But those are just some of the high level themes, and of course there are other considerations too.
Understood. Well, look, those are great insights, Kumar. Thank you very much. I had been hoping to share some thoughts with the group and the audience on a subject that is close to my heart as an M&A lawyer, which is the use of warranty and indemnity insurance to mitigate the risk on M&A transactions. I hope, Alex, that you give me a chance to talk to the association's members about that topic on another occasion, because I think we probably run out of time for today's session. So all that remains for me to do, I think, is to thank Kumar and Ioana and Tim very much indeed for your contributions. I hope that the audience would have found them interesting to listen to, and I'll hand back to you, Alex.
Thank you, Stephen. Thank you all for this very interesting topics, and I really like the fact that it was really separated. You know, it's like different topics within the legal aspect. So thank you very much for this. I hope to see you in another panel very soon. Thank you for all the information. It's fantastic. I really appreciate it, and it's a good way to start the year with this webinar. All right, thank you very much, and I hope to see you very soon. Thank you. Bye bye.
Thank you.
Bye bye.
Bye bye.
Bye.